This talk summarises research undertaken by the School of Law at the University of Leeds, funded by the disabled children's charity Cerebra, concerning English social services policies that have the effect of institutionalising parent-carer blame. And in this talk, I'll explain what we mean by that concept. Cerebra was receiving many reports from parents of disabled children who were distressed when they made contact with their local children's services because they needed support because of their child's impairment. And instead of receiving that support, what the parents were relating to Cerebra and to ourselves was that they were treated as if they themselves were neglectful or abusive, inadequate parents. Assessors would visit their homes, unannounced sometimes, but at very short notice very often, and insist on seeing the child's bedroom and interviewing the children alone. And the outcome of their request for help and these intrusive investigations wasn't medium or long-term support. It was that the parents were then sent on a parenting course, as if the parents themselves were at fault. And this left them distraught and humiliated. It was decided the Leeds Research Unit would undertake a project to assess how prevalent action of this kind was, and if it was widespread, why was it happening?
We have to make sure that if there is any evidence, any inkling, any iota of harm to any child, the child is taken away immediately.
Why do local authorities direct parents of children with disabilities who need support to effectively child protection, safeguarding teams? Why do they do this when there's no evidence in the referral of child neglect or child abuse? Why do local authorities insist that disabled children be interviewed alone, that their bedrooms be inspected, that there be regular home visits at short notice or even unannounced? Why is parenting advice or early help considered an appropriate or indeed the only response? Parenting advice seems to locate the problem in the parents. And how can action of this kind, highly intrusive action into people's private and family lives, be justified in terms of their fundamental human rights?
The bottom line is that terrorism has always been what we in the intelligence world would call a cover for action. Terrorism is something that provokes an emotional response that allows people to rationalize authorizing powers and programs that they wouldn't give otherwise. And it's that kind of government behind closed doors that we need to guard ourselves against.
It's an approach that locates the problems associated with a child's impairment in the family. It's a phenomenon we refer to as institutionalizing parent-carer blame. And a significant reason for this approach is to be laid at the door of the guidance issued It fails to address the distinct assessment and support needs of disabled children for whom there's no evidence of neglect or abuse. It doesn't contain any requirement that those assessing the needs of disabled children have any impairment-specific expertise, something that must be vital if the needs of disabled children are to be accurately identified. Of the 143 local authority assessment protocols we identified, none contained a clear explanation that a different approach should be taken concerning the assessment of the needs of disabled children where the referral was not accompanied by evidence of neglect or abuse. 80% required the assessor to confirm if the child's bedroom had been seen, regardless of whether there was any evidence of neglect or abuse. 87% referred to the need of seeing or communicating with the child alone, again, regardless of whether there was any evidence of neglect or abuse. And none gave evidence or gave guidance to assessors concerning the need for cogent ground to exist before seeking to see a child's bedroom or seeking to interview a child in the absence of their parents. at law, these are intimate examples of family and private life, and the state shouldn't seek to interfere with those without compelling grounds. Of the survey of parent carer support groups, 86% considered the assessment process to be extremely unsatisfactory and intrusive. And in those 86% of responses, highlighted were such factors as assessors lacking training and understanding concerning the disability-related challenges that disabled children and their families encounter, the intimidating nature of the assessment process, a process that focused on safeguarding, child protection, and parental fitness, rather than the additional support needs that resulted from the child's impairment. And the intrusive nature of the process, with families widely reporting that the assessment visits could take place with little or no notice, and that they were often placed in an impossible position when a social worker turned up at the door. The point, I suppose, that one has to appreciate, and I think it must be fairly obvious, is that disabled children are different to children who are suspected of being neglected or abused. And treating disabled children simply as children in need due to neglect or abuse means that they're often denied access to their legal entitlement.
One of the questions the researchers asked was why children with disabilities were being put in the same camp as children who were being abused or neglected. What is being said here is that when that is done, it means that the child with a disability is denied access to entitled adjustments. Another way to understand this is that the local authority doesn't have to fund their entitlement. It makes more commercial sense to treat the parents as neglectful or bad parents rather than to acknowledge the very real struggle the child is enduring. To nip claims of disability in the bud, politicians attempt to publicly shame parents as bad parents when they have children with special needs. MP James Daly blamed the struggles of any children in his constituency on the crap parents. Councillor Jeff Morgan questioned whether some children receiving funding were just really badly behaved.
Unless disabled children are assessed as disabled children, they're not going to access these rights that Parliament has set aside for them. And that in itself amounts to unlawful discrimination. So essentially what we're seeing is there should be two different assessment routes for children in need. One for children in need whose need arises out of their impairments for disabled children, and a different route for children in need whose need arises out of neglect or abuse. The disabled child assessment process should focus on the impairment. So it needs to be undertaken by somebody from a team that has got expert in impairment-specific conditions. They'll be looking at longer-term support. And once the child reaches their majority, there'll need to be a plan to hand over responsibility from children's services to adult services, a transition plan. But what our research found was that in nearly every case, except in cases of the most severe impairments, disabled children were actually being channeled down and assessed by the Children in Need team, the team that was responsible for children suspected of neglect or abuse. And often these were called early help teams, teams that were put in short-term interventions to correct poor parenting. And if that failed, then the ratchet would be turned and the local authority would consider taking safeguarding proceedings, Section 47 assessments. And if that failed, then the child could become a looked after child, or there could be care proceedings. Shortly before we published the final research report, two official publications drew attention to the problem in powerful terms. One, written by the Chief Social Workers for Adults and the Chief Social Worker for Children and Families in England and published by the Department of Health, said very similar things. Even where the sole reason for contact with children's social care was because of the social care needs of an autistic child, there was a tendency to use the social work assessment as an opportunity to judge parenting capacity through a child protection lens rather than through a lens of social care need. This has long been a complaint of families caring for disabled children. And another report, the McAllister Review, said a consistent theme in what the review has heard is that families with disabled children felt that they are navigating a system that is set up for child protection and not support. As I say, the research report articulates these failings in the language of the law. And most obviously, what we are seeing is families with disabled children being subjected to really severe and very troubling interferences with their private and family lives. And such action contravenes basic common law within the United Kingdom, but also the Human Rights Act of 1998. Article 8 of that says that there is a right to respect for private and family life and one's home. And although states can interfere with that right, this interference can only happen where there's cogent evidence to justify it. And as I've already said, in the research, we found no evidence that there is neglect or abuse. Then there really is no justification for insisting that the children be interviewed alone, that bedrooms be inspected. The state might argue that, of course, the social worker asks, can I see the bedroom? Can I interview the child on their own? They are pretend choices because they believe that if they say no, then that will be taken as evidence that they have something to hide, that they are being obstructive. Sometimes when it's put to social services, why are you doing this? They'll say, well, you know, disabled children are at a higher risk of abuse than non-disabled children. And on the slide that I've just shown, there's a link to a paper I've written explaining not only does the data not show that parents are more likely to abuse disabled children than non-disabled children, but also stereotyping of that kind is itself a form of discrimination. The first, and I think one of the most important things, is to raise awareness of the problem, to use media to explain what is happening, why it's happening, and why it is wrong. Many social workers are going into homes and doing these things that are deeply distressing, but they're not doing it deliberately. They're just not thinking. They're not mindful of the professional problems that they're creating. Many local authorities accept that this is something that has incrementally developed and needs changing, and therefore have been open to really positive and meaningful discussions with parent carer groups. And many of these things do not require huge resources or major upheavals, organizational turmoil. Many of them are sort of tonal as much as substantive. For example, I hear time and time again that families are saying what we want is just a listening, a welcoming, an accessible, a kind response, a response that says it must be incredibly difficult to have a child with these impairments. It must be a great strain, some empathy rather than judgmentality. That disabled children are not referred to the stigmatizing, safeguarding, child protection, multi-agency safeguarding hubs, but to a single point of contact for disabled children. There will be some more webinars, a number of further webinars as we do move forward with implementation and change. And those will be free webinars, and they will be advertised both by the School of Law at Leeds University and also by Cerebra. So I hope that's been a helpful summary of the work that we've done on this issue, and many thanks for taking time to listen to it.